Here's something that will make your jaw drop. Melania Trump is currently arguing in federal court in an actual legal filing submitted by actual lawyers with her name on it that it would violate her constitutional rights, her due process rights, her fundamental sense of fair play and substantial justice to have to respond to a lawsuit in New York. New York, the city she has called, in her own words, on her own social media, in front of thousands of people at Madison Square Garden during a presidential campaign, her home. That's where we are. And I promise you, it gets so much more interesting from there. Let's back up. Because to understand what's happening right now in federal court, you need to understand how we got here and who the players are and why this particular legal fight matters beyond just the celebrity names attached to it. Michael Wolff is an author. He's written things, reported things about Melania Trump's relationship with Jeffrey Epstein and Ghislaine Maxwell. Melania did not like what he wrote. And so in October, she did what powerful people sometimes do when they don't like what someone has published about them. She sent him a demand letter, a very aggressive demand letter. She told him he had until a specific deadline to apologize and retract what he had written. And if he didn't, she was going to sue him, not for a small amount, not for some nominal figure. She told Michael Wolff she was going to sue him for $1 billion. Now, a lot of people, when they receive a letter like that, get scared. That's frequently the point. $1 billion threat from a sitting First Lady of the United States is designed to make someone think very carefully about whether they want to keep publishing, keep talking, keep existing in the space where that threat is being made. It has a chilling effect. That's the intent. But Michael Wolff didn't retract. He didn't apologize. He did something else entirely. He sued her first. Wolff filed what's called an anti-SLAPP lawsuit in New York State court. SLAPP stands for Strategic Lawsuit Against Public Participation, and anti-SLAPP laws exist precisely for situations like this one. They're a legal tool designed to protect people, journalists, authors, critics, citizens, from being silenced by the threat of expensive, ruinous litigation from powerful entities who don't actually want their day in court. They just want you to shut up. Anti-SLAPP laws say you can't do that. And if you try, we have something for you. So Wolff is in New York State court. He lives in New York. That's where you'd expect this case to be. Except then something genuinely unusual happened. Melania Trump avoided service. When someone sues you, a process server has to physically hand you the legal papers. It's called service of process. It is one of the most basic, foundational requirements of the American legal system. You have to be formally notified that someone is suing you before the court can proceed. And Melania Trump, the First Lady of the United States, apparently dodged the process server. She hid. She made herself unavailable. She did not accept the papers. And then she showed up in federal court, not the state court where Wolff filed, federal court. And she filed a removal, arguing that the case doesn't belong in New York State court at all, because she doesn't actually live in New York. She lives in Florida, she says, at Mar-a-Lago. She has a Florida driver's license, a Florida mailing address. She votes in Florida, and because she lives in Florida and Wolff lives in New York, and the amount in question exceeds $75,000, well, that's what's called diversity jurisdiction. And diversity jurisdiction means federal court, and not just any federal court. She wants it in Florida. So to recap, she threatened to sue him in New York, where he lives. He sued her first in New York, where he lives. And now she's arguing that having to litigate in New York, where he lives, the place where she threatened to sue him, violates her constitutional rights. I want to read you the exact language from her court filing because it's important to sit with it. She wrote that it is, quote, difficult to fathom a scenario less offensive to traditional notions of fair play and substantial justice than being forced to litigate in New York against the person she threatened to sue in New York. She cannot fathom it. The mind reels. She also argues that because she successfully avoided the process server, the case should be dismissed. Let that sink in. Her argument is, I hid from service, therefore the lawsuit should be thrown out. Courts, generally speaking, do not reward that behavior. Arguing that someone shouldn't have to face a lawsuit because they were good at hiding is not traditionally a winning legal strategy. It might delay things, but it tends not to end them. Now, here's where it gets truly extraordinary. Because while all of this is happening in federal court, something else happened that throws Melania's core legal argument into a very different light. The Epstein files were released. The Department of Justice released a batch of documents connected to Jeffrey Epstein, and Melania Trump's name is in there. There is an email from 2002, Melania writing to Ghislaine Maxwell, whom she addresses as simply G, praising a New York Magazine feature about Jeffrey Epstein. You may remember that particular article. That's the one where Donald Trump described Epstein as, quote, a terrific guy who likes women on the younger side. That article. Melania is writing to Ghislaine Maxwell, telling her she looks amazing in the photos from that piece. Maxwell writes back. She calls Melania Sweet Pea. She says she's too busy to meet up in New York right now, but they'll figure out a time. These are not allegations. These are not rumors. These emails are in the official record. They exist in the documents released by the federal government. And now let's return to what Melania is simultaneously arguing in federal court. She is claiming that Michael Wolff damaged her reputation to the tune of $1 billion. She is describing that reputation in her own legal filing as sterling. That is her word, sterling. She writes that Wolff's statements were maliciously intended to destroy Mrs. Trump's sterling reputation. Sterling. While the emails between her and Ghislaine Maxwell sit in the public record, Wolff's argument about why the case belongs in New York is detailed and specific. He points to her own documentary. He says she's in New York throughout the entire film. He lists the apartment in Trump Tower where he says she actually lives, not the penthouse, a different apartment. He says her son lives there. Her staff works there. He cites her social media posts from 2024 where she describes New York as her home. He references her speech at Madison Square Garden where she essentially told the crowd she was home. He is using her own words, her own images, her own public record against her contention that she's just a Florida resident with no meaningful connection to New York. When she says it is undisputed that she's not a New York domiciliary, Wolff's response is, we dispute that entirely. Her whole argument, he says, is an artifice, a legal construction designed to manipulate jurisdiction, to get this case in front of a friendlier judge in a friendlier venue, as far from a New York jury as possible. And here is the question you have to ask. If Melania Trump genuinely believes that Michael Wolff destroyed her sterling reputation to the tune of $1 billion, why is she fighting so hard to avoid litigating the case? If the defamation is as clear and devastating as she claims in her filing, why not prove it? Why not take his deposition? Why not walk into a New York courtroom and make your case? Because if this case goes forward, her lawyers don't get to ask questions. His lawyers do. Wolff's attorneys would get to depose her. 7 hours on camera, under oath, with a transcript that becomes part of the public record. They would get to ask her about those Ghislaine Maxwell emails. They would get to ask her about Jeffrey Epstein. They would get to ask her about where she actually lives, what her actual life looks like, who she actually knows. That is what discovery looks like, and she does not want it. This is not the first time she has threatened a massive lawsuit and then found reasons not to follow through. She also threatened to sue Hunter Biden for $1 billion. She did not file that lawsuit either. The pattern is consistent. The threat is the weapon. The lawsuit itself was never the point. Once someone fights back, once the legal machinery starts moving in ways that could produce discovery and depositions and sworn testimony, the whole enterprise becomes considerably less attractive. Anti-SLAPP laws exist because legislators recognize this dynamic. Powerful people and institutions discovered that you don't actually have to win a lawsuit to destroy someone. You just have to threaten one. Make the legal fees high enough, make the process painful enough, and most people will back down. Anti-SLAPP laws are the legislature saying, not so fast. You can't use the threat of litigation as a silencing mechanism and then walk away clean. There are consequences for that. The judge in this case has not yet ruled on the motion to dismiss or the motion to transfer to Florida. We are waiting. But what's already in the record is remarkable enough on its own. A first lady hiding from a process server, a $1 billion reputation claim filed while Epstein documents with her name on them sit in the public archive, a due process argument that, when you read it carefully, essentially says it is fundamentally unjust that I have to respond to a lawsuit in the city where I threatened to file one. A Florida residency claim contradicted by years of public statements made by the person making the claim. There's a broader principle at work here, and it matters. The question of whether public figures can use the threat of catastrophic litigation to silence people who write critical things about them is not an abstract legal question. It has real consequences for what journalists can report, what authors can publish, what citizens can say. The answer that anti-SLAPP laws provide is there are limits. You cannot weaponize the legal system to suppress speech and then cry victim when the speech doesn't stop. Michael Wolff wrote things about Melania Trump. She didn't like them. She threatened to destroy him financially. He said no, and he used the tools the law provides to protect his ability to say so. And now in federal court in New York, we are watching what happens when someone fights back against that kind of threat, and the person who made it doesn't actually want to litigate. They just want the whole thing to go away as quietly as possible on as technical a legal basis as they can find before anyone gets to ask any questions under oath. The case is pending. The judge will rule. And one way or another, we will find out whether hiding from a process server, claiming Florida residency against the weight of your own public record, and arguing that New York is an unconstitutional venue for a lawsuit you started is enough to make a federal court say, fine, case dismissed, stay with this one, because something tells me we are nowhere near the end of it.